Good evening, everyone, and welcome to the planning meeting for the Melton Borough Council. I'm Councillor Alan Thwaites, Chair of Planning. Before we start, I just want to go through some housekeeping. In the event of having to evacuate the council chamber, please leave by one of the 6 emergency exits around the sides of the chamber. Please assemble at the far side of the front car park nearest the park entrance. Officers will be on hand to assist anyone who needs any assistance. Please put your phone on silent during this meeting. We will be using the audio-visual system this evening, and the meeting will also be streamed live on YouTube. Members speaking, please raise your hand if you wish to speak and speak directly into the microphone in front of you. Please remember to turn it off once you're finished. Members voting will be by raised hands. I'd like to introduce those present this evening. The members to my right is James Mason, Vice Chair, Councillor Allnutt, Councillor Ian Atherton, Councillor Siggy Atherton, Councillor Evans, Councillor Pritchett, Councillor Gordon. To my left should be Councillor Cumbers, but she's going to be slightly late, Councillor Nancy and Councillor Higgins. We have a team of officers present who are, to my right, Legal Advisor Tom Pickwell, to my left, Planning Development Manager Louise Parker, Assistant Director for Planning Sarah Legg, Senior Planning Officer Andrew Cunningham, Planning Officer Helen White. We also have our Democratic Services team present, assisting with the technology and taking the minutes. That's Helen Ainge and Sarah Evans. So moving on to the agenda. Apologies for absence. As I've just mentioned, Councillor Siggy Atherton is actually substituting for Councillor Brown, who's away at the moment. Moving on to the minutes of the last meeting, which was held on the 30th of March, we only had 2 people that were actually present at that meeting. So I'm going to rely on those 2 people present to see if you'll propose and second, or if there was any amendments to the minutes that you would like to make.
Thank you, Chairman. I'll propose the minutes as they are.
Thank you.
I'll second them.
Thank you. I'll take that as a unanimous vote then. Thank you. The next point is any declarations of interest. Do any of the members wish to put any declarations of interest? No. I have one of my own. For transparency, the speaker, Rob Hughes, for the second application we're talking about, is actually my next door neighbour, although I have no pecuniary interest. I'll learn to say that word one day. And we have not discussed this application or any applications at all. So I've taken advice and feel that's okay. So if we're ready, we'll actually sort of look at the first application, which is application 22/00006/VAC. Canal Lane Hose, and Andrew is going to present. Thank you.
Thank you, Chair. So before I start, just to advise, we've received 2 further letters of representation raising concerns about the viability report that's been submitted, and also regarding contributions towards the local village facilities. The viability appraisal has obviously already been fully assessed within the report itself, and with respect to the local village facilities, the contributions have already been secured at the outline stage, so that wouldn't be for consideration here as part of the determination of this application. Next slide, please. Thank you. So this application seeks to remove condition 4 of a 2019 outline planning application for the development of 34 houses at Canal Lane in Hose. Condition 4 is on the screen in front of you, and it sought the provision of 32% affordable housing across the development, which equated to 11 out of the 34 houses. So in essence, this application seeks to remove the requirement to provide affordable housing on site. Next slide, please. Thank you. A viability appraisal was submitted by the applicant, demonstrating that a policy compliant provision of 32% affordable housing would result in a negative viability outcome, and that is the top bullet point on the slide on the screen. There was a number of different scenarios tested as well. So even a 100% market scheme, so no affordable housing across the site, would also result in a negative viability outcome, and that's the middle bullet point. And then further sort of scrutinizing and working through the viability appraisal further, even a 100% market scheme and reducing the profit and the contingency allowances would still result in a negative viability outcome. So the applicant's appraisal that has been submitted was independently and externally assessed as part of the application, and a copy of that report is included within the committee extract. And that confirms that the scheme would not be viable when providing any percentage of on-site affordable housing. Separate to that, we also undertook a specialist cost review of the applicant's figures, so a detailed analysis of the construction costs that were put forward. So that review again was undertaken to make sure that everything was in order effectively. The next slide, please. So thank you. Yeah. So it is obviously disappointing that the proposal here that's before you does result in the removal of affordable housing on site. However, the policies here, the framework and the relevant planning guidance does allow for viability as a mechanism and a forms of material consideration as part of the determination of this application, and must be considered as such. I should note that we have looked at in detail, so we have been back and forth with the viability consultant that we hired to undertake the review. So we have robustly analysed the information that's been submitted before bringing this to the planning committee. In line with the developer contributions supplementary planning document, we can look at priority setting. So as part of the recommendation in front of you, we would look to remove the contributions to the local infrastructure services that sit below affordable housing in the priorities list, and that would go towards an off-site affordable housing contribution. It's the figures and all the detail are in the report, but it's approximately just over 43,000. Further to this, as part of the recommendation, it's also proposed to include a late stage review mechanism, and that's so we can review the actual build costs and actual sales values of the development with a percentage of any additional surplus, again going towards that off-site affordable housing commuted sum. Responding to a couple of member queries that came in last week following the publication of the report about when that review would take place. So we would look to take that review as late as we can within the development. So ideally between when 80% and 90% of the houses have been sold, but we wouldn't recommend to go any later than that, just from a risk point of view and making sure that the review is actually carried out. Responding to another query that was raised regarding sort of where the affordable housing contribution would be spent. Again, a local cascade criteria can be included within the deed of variation, and that would ensure that the money would look to be spent initially within the village of Hose and then wider within the parish and adjoining parish, and then elsewhere within the borough. So overall, we've undertaken a detailed consideration and a robust analysis of the information that's been submitted. The scheme would not be viable when providing any percentage of affordable housing, and therefore the application is recommended for approval subject to that deed of variation, which includes the priority setting and the late stage review mechanism. Thank you.
Thank you, Andrew. I'll now ask if any of the members have any questions for Andrew to clarify any further facts. Councillor Evans.
Thank you, Andrew. Just so we have clarification here, the negative viability and the lowest figure we have is minus 0.9 million. Does that include the 15% profit, or is it exclusive? In other words, obviously, if it's minus 0.9 million, then there's going to be no profit for the builder at all, or is that taken after he's had his 15%, or she has had the 15% profit minimum?
Thank you. So that would be after the 15%. So it's not it would be based upon sort of 0.9 less than 15% profit, which was the third bullet point. The other two bullet points were based on the 20% profit. So they're not making a loss. It's just not in, it's just less than what the viability guidance states for developers' profit, which is set between 15 and 20%.
I'd just come back on that and say, what is 15% profit on this project, as it were, then? In other words, how much profit is he really making if he gets 15%?
Thank you. I don't have the answer to that myself, but it might be one that the applicant might be able to advise on.
Any other questions? Councillor Arnott.
Thank you, Chairman. And welcome to your new role. Can I say, first of all, that I did read all the reports last night for a very long time, and I'd like to commend the officers for a very clear exposition of the issues. I had no difficulty grasping it, even at my old age. Now, a couple of questions I have. On page 12 of the document, where we've got a long list of recommendations, and at item 2, there is the deeded variation. It references primary and secondary education provision, but on later down in the document, where I think it's page 17, at 8.3, you've got a list here, which is, you've got some values against contributions, and it mentions secondary education provision. Now, is that the same thing, or is there something omitted there? Perhaps if you could deal with that first.
Thank you. Yeah, so that is secondary education provision. So that was secured during the 2019 outline planning application, and my understanding is that it was for secondary education only.
Does that mean that going back to page 12, the word primary, is that a typo, or is it something that's just fallen off the end?
I think it was a generic sort of phrase in terms of the education
right.
provision.
So it wasn't
in total.
specific.
Yeah.
Okay, fair enough. And can you refresh my memory, please? When does that, sorry, Chairman, through you, when does that cash actually get paid, and to whom?
So that would be within the section 106. There would be a number of sort of trigger points as to when the money would be required to be paid to the county council in this instance for the education provision.
Thank you for the additional information about the fact that at a subsequent stage, further money might be available for you mentioned cascading for additional housing within Hose. Does that mean that within the existing local plan that there is sites within the red line, or that we've got our eyes on where it could go for affordable housing, or is this just a general speculation at this stage?
So I wouldn't be able to comment on any sites because that would be dealt with by a separate team, but it would go into sort of the generic affordable housing sum, and where it would initially look to be spent within the village of Hose. And then if there's nothing coming forward, then it would go within the wider parish and a sort of cascade through the tiers sort of over the time period.
Okay, one more.
Promise. It's more of a legal thing, really. We have the independent viability assessment. Now, as I understand it, if we recommend something that's contrary to that recommendation, we're exposed to legal challenge. Is that correct, or am I mistaken?
Yeah. So are we talking about in terms of how you decide to proceed with this application? Are you open to legal challenge? This is a Section 73 application. The relevance of that is it means it's a new planning application, a new planning permission. So it would be through the planning inspectorate. Should you refuse the application, the applicant could take that to the planning inspectorate to look at. If you were to approve it, the only way to sort of then go from there would be a judicial review if somebody wanted to oppose your recommendation to approve. But no, it'd be through the planning inspectorate in the first instance in ordinary circumstances.
Chairman, I'm not talking about approval. I'm talking about disapproval of the application to vary it. Now, I just want to get a clear understanding. When a viability test by an independent body is undertaken, is that like a sort of an arbitration where both sides have to abide by it? But how much weight would an inspector attach to that if we went against the recommendation of the independent tester?
Obviously, I can't answer for the planning inspectorate of what weights they would give. However, the applicant has produced a study and given their figures, and that's been independently assessed and come out at roughly the same, I believe. The relevance of that being an inspector is likely to give it a lot of weight because they both match up.
Are there any other questions? Councillor Gordon.
Yeah, now if this goes through, I understand that the for the affordable housing, the monies that that will be put into the coffers, from what I understand, and I know it can't be earmarked for hose, but this is where I think there is a problem, because I think somehow or other the money does have to go back to hose, and I was wondering if at full council that they have the powers to earmark it for hose.
Marilyn, I think
If there's any way.
Andrew actually already said that we would be I don't know whether ring fencing is the right word, but
Oh,
the
it
money would be
ring
kept
fence.
for
Oh,
hose.
right, sorry, yeah, I missed that bit. Yeah, okay, thank you.
Any other questions? Did I see Councillor Evans?
One last one, there was reference in your report, Andrew, to the fact that there always should be on a big development an initial viability study. Obviously, it was at the outline stage, but it's very important that all major sites have an initial viability study to actually assess whether they can be profitable or not at that stage. Was that done?
So again, I don't know if the applicant carried out one initially before sort of submitting the outline application, but there was a viability assessment submitted at the outline stage.
Yeah,
but that was based on sort of average costs, whereas now we've had the reserve matters approval, so the detail of that development has actually been sort of fixed in stone. So therefore, there's more sort of robustness and evidence behind the now submitted viability appraisal.
If I may just come back on that, Chair, have we got those figures at all or not?
So from the 2019 viability assessment, so the independent assessor at the 2019 stage did find that the scheme was viable, but again, that was based on sort of generic costs of a development of 34 houses, whereas this is more of a detailed assessment.
Andrews, that's exactly what I want to hear, Shahab. So it was viable when the outline plan went through. Thank you.
Councillor Higgins. Sorry.
Thank you. I think it is in the report, but as there's lots of documents here, could you advise the committee what the land value was to the landowner and how that's being considered, please? Thank you.
I may have to come back to you on that one if that's okay.
Yeah, that's okay through you, Chair, but I think that may come up in debate.
Yeah, one supplementary question to that is when do we know when that payment or when that price will be set? I'm not asking for an answer now, but at what point will that price be set that we can use in the late stage evaluation, if that's the option? Yeah. Any other questions? No, I can't see any hands. So therefore, I'd like to move on to the speaker that we have for, which is Adrian Kerrison. If you'd like to come forward. Thank you very much. If you press the face in the middle, the red light should come on. You'll have 3 minutes to talk. Tom will give you a warning at 30 seconds, but I think if you're almost there, please finish. Thank you
Okay.
very much.
Okay, firstly, thank you for the opportunity to speak to you this evening. I hope you've all received the supporting information I circulated on Friday, but to briefly summarise some of those points. The historical context. I would hope the members acknowledge that residential property development is in a very different place now than when the affordable housing viability was assessed and targets established for the local plan in 2017. The sales and cost figures I have circulated to you illustrate in that time there's been a 15% increase in property sale values, but a 55% increase in construction costs. This is due to a combination of factors: Brexit, COVID, the latest general cost increases that everyone's experiencing. It's just that these inflation factors began to hit the construction industry about 5 years ago, and they haven't abated. As such, the margin between property value and development cost has shrunk to the point where it's very difficult to make full developer contribution requirements outside perhaps the southeast and the more affluent areas of the country. There are also site-specific factors for this development and indeed the scale of this type of development that make it difficult to generate margin for Section 106 payments. Development has over £680,000 of abnormal development costs to overcome, which are itemised in my letter to you. And we, as small local developers, do not enjoy the purchasing power of the volume house builders. And cost rates on this sort of sub 50 unit site that volume house builders wouldn't consider are much higher. As such, while you may have seen larger sites in the borough commit to affordable housing provision, smaller house building companies like us find it much harder to make things work. Similarly, it's important not to be misled by some outline consents that you'll no doubt see committing to full social housing provision. These are often promoted by landowners who simply need a planning permission of any description to sell their land and will sign up to any requirements put before them without necessarily understanding the value versus cost equation of actually delivering the scheme. Now, all of the assessments that have been undertaken, that's our assessments and your own independent assessments, have shown that it's not possible to viably deliver affordable housing contributions. Your own assessor estimated the cost of those affordable housing commitments to be £1.3 million.
30 seconds remaining.
Okay. Even the best case sensitivity analysis shows a 0.9 million negative viability. That doesn't, of course, mean it's making a loss. It means it's making a reduced profit from the normal of about 10% compared to the generally accepted target in this area of 20%. So the scheme can go ahead, and we would hope that market circumstances improve over the next couple of years to improve our returns. And that, of course, is where your viability review mechanism would come in and enable, additional money to be captured to release affordable housing.
Thank you very much. Please stay seated. And are there any questions from the members? Councillor Pritchett.
Thank you. Just firstly, for clarity, I didn't see the recent letter. It went into my quarantine emails box and I'm unable to extract it, and I've reported it to Democracy to get IT involved. Two questions. Firstly, the 10% you're talking about, is that gross profit or net company profit?
That's gross profit.
Yeah, there will be office expenses
Yes.
for the year off that. Just
Yes.
making the difference clear. You mentioned £680,000 of abnormal costs.
Yes.
Could you just briefly run through
Yes.
the key points?
Find the list here, but there's some very significant cut and fill required. You've probably seen, or members that know that site, there's probably a 6 metre slope from the top corner to the bottom corner. We have to create a number of plateaus to make the various different parts of the site work. There's, I think, £150,000 worth of cut and fill. There's a new rising main to put in and a foul pumping station. That's a 6-figure sum. There's a large attenuation pond. Again, that's about 6 figures. There is a road widening scheme required by the county council all the way down the frontage. I think that's nearly £160,000. All of those things. There's various other things. There's archaeology, which has been done. There's a newt issue which has been resolved, but again, that was probably £30,000 worth of costs. In all, a total £680,000, which, whilst it's a greenfield site, there are some unusual circumstances on that site.
Any other questions? I could take Councillor Evans first and then Councillor Pritchett.
We've been through a lot, haven't we? We've had probably 3 or 4 meetings. I'm a ward member, so I've had 3 or 4 meetings with the applicant. We've always got on, I think, fairly well.
Yes.
We've had our fraught moments, but we've got through it all. Can I summarize what you're saying is basically, if we were sitting here 2 or 3 years ago, we wouldn't be looking, from what you're saying, at the need to, well, remove the affordables, because the profit would be such that we'd be able to build, you would be able to build them. But as you've said, there's been a 55% in construction costs. So what you're saying is it's market forces that have driven you to this, nothing else is apart from the site. You listed a load of things on the sites, but I'm around a small ward and I know each one has those kind of issues with height and all the rest of it, because we're in the Vale of Belvoir. But the main thing that's driven this no affordable homes is the market forces over the last 2 years.
Well, if I may,
3 years.
sorry, yes, if I may clarify that, I would just take issue with Andrew's response to your question. We submitted a viability appraisal in 2019 with the original outline application, which showed that 32% affordable housing was never viable. What we did offer was a smaller percentage of discount for sale market houses, which, as you probably know, are a legitimate form of affordable housing, but they're sold at 80% of market value, as opposed to the council's policy for social rent, affordable rent, shared ownership, which vary from 40% of market value to sort of 60%, which has a massive impact on viability. So no, at no point did we ever say we could deliver the full affordable housing. We were going to offer a lesser amount, and we had some pretty serious issues at that time with the council's independent assessor, who, I think, to be fair, Andrew, never said it was viable to deliver 32% affordable. He just said that it could do more than we said it could at the time. So things have got worse. They were starting to get worse. They were getting worse between 2017, I'd say, and 2019, but they got significantly worse, yes, over the last 3 to 4 years.
Or is it possible for the officer to reply to that? Because some of this is kind of news to me and to the probably the parish council, because we never got that feeling that you weren't able to deliver, hence the outline planning and full planning, which was with 30%.
Time in the outline, we refused to sign a Section 106 agreement that said we would deliver affordable housing. And we set it aside, if you like. It became a planning condition that we would submit further details during the detailed stages to determine how much affordable housing could be delivered. That's why we didn't sign up to that. So at no stage did we ever say it was viable.
Have you ever signed up to a Section 106 at all then?
We signed up to the infrastructure payments, and we're not seeking to vary those. It was just the affordable housing element that, I think, through negotiation with Louise and Andrew, we've all been at this for quite some time now, that we agreed would be looked at again as detail planning permission was granted, so you could see what we were actually building and assess that.
Andrew, Louise, can you?
That is the case. Effectively, the applicant came in at the outline stage to demonstrate that the scheme was not viable, and we went out to an independent assessor at that point. But there was a sort of a conflict over the detailed costs that were submitted at that point. So that's why we looked at getting the reserved matters in, and that's why the applicant agreed to sort of go down that route, submit the reserved matters. get the detail in, and that's where we are now. And that's what we need to consider as part of this application, is the viability assessment that has been submitted, and it's based on the detailed costs. And as I said in my presentation, we've been out to a separate sort of cost consultant as well. So aside to the independent assessor, again, to sort of scrutinise the detail that the applicant has submitted, which has come back to say that the scheme would not be viable based on the information that's been submitted with this application. And that's what we need to consider now.
Councillor Pritchett.
Just to close the point, the reason I asked about the abnormals is because when I see a list of abnormals, most of it is actually normal. We have to have attenuation ponds and things normally. So I asked for the list so I could flesh out what is abnormal from normal. Thank you.
I must agree with that, that most of those issues you must have seen when you purchased the land.
The attenuation pond one, yeah, I say that's possibly debatable, but the others are not normal development costs that you would find on every site. Certainly things like a foul pumping station and the cut and fill and the road widening are not things that happen on every greenfield site, no.
Councillor Sigley, Atherton.
But surely when you looked at considering building there, you would have looked at the site and would have seen there were slopes, that a road would need widening. That's things that you would have seen when you inspected the site to start building. So that must have been straight away part of your calculation, what you needed to put in before you even start, surely.
Yes, it was, which is why right from the off, when I walked through the door at Melton Borough Council and spoke to Andrew and Louise, right from the very first meeting, we made it clear we couldn't deliver 32% affordable housing. And we would have to look at a much reduced contribution. I've been consistent in that for the last 4 years.
You said earlier on you were looking at giving some houses a reduced price. Is that still in the picture or is that completely out now?
Since 2019, I say the cost situation has got significantly worse to the point now where we can't deliver any, and obviously that's what your independent assessor has also concluded.
Thank you. Councillor Higgins.
Just a question. When did you purchase the land, or when did you acquire the interest in the land?
That was in I think early 2019. So the land value that was agreed then would be the land value that stays for any further assessment or reassessment. I think it was about £1 million.
Thank you. And just to remind me and maybe other committee members who may have been at that original, when was the decision made by the committee? Does anyone know? I've got the application here.
Which decision on the outline consent? Yeah. I think it was it 2020? I can't remember now.
It's the 23rd of July 2020 was the committee date.
Any other questions? There's just one question I'd like to ask myself. The houses that were originally set for affordable housing, you're still obviously building that because the footprint is staying the same. What is making it different now between them being affordable and being commercial?
Nothing in that. I think we always felt in our initial proposals, if we were going to do an affordable housing provision back in 2019, it was going to be discount for sale. So they are effectively market houses, small 2 and 3 bed houses, which they still will be, but they're identical to a market house. They're just sold at 80% of the price. Because they don't have to meet the specification criteria of Homes England for social rent funding, which do change affordable housing units of that category.
Thank you. Any other questions? Councillor Gancy?
Yes, just quickly through you, Chair. Have you looked at making alterations to your build? I notice you're going to be putting wood burning fires stoves into each development, into each house at £3,000 per property. Have you looked at sort of altering your building spec to accommodate these discount market homes, in which case we'd still be in the same position, but we have a few affordables?
What we provide is obviously we're a small house builder with a particular market. We look at building sort of reasonably high specification houses, but that's why the values in this assessment are much higher than anything that I think has so far been achieved in Howes. We went through an exercise with Andrew to say if we took a completely different approach, if you're more like a volume house builder approach, and we reduced all the specifications, reduced the construction costs, it would obviously also reduce values significantly. We did that calculation and it still showed it would not be viable. It's just obviously on both sides of the equation.
Councillor Siggy Atherton.
So you build in high spec houses. 5 minutes ago, you talked about everybody's hit by the financial crisis and cost of living. How are you expecting to sell them at such a high cost when everybody's struggling to buy daily products? I don't think Melton House in Loughborough has got that many extremely rich people that can afford it.
Well, I think you have to look at the scale, excuse me, the scale of development. We will have, I think there are 14 4-bed houses, the larger ones. There'll be difference in sizes of those, and their prices will vary significantly, probably between somewhere in the 600s to the most expensive at 800. But there'll be a third of those houses, 11 of the 2 and 3-bed houses, that'll be in the 250,000 starting price range, or 220,000 starting price range. So there's quite a mix and range of houses on that site. And there's some, interim ones. There's some 1,500 square foot 3-bed houses down to, I think they haven't all been designed. And of course, importantly, there are 6 bungalows in the central courtyard, which will meet another type of need. So that there will be, a variation between the top price and the bottom price of probably £550,000. So hopefully there's something for everybody.
Councillor Pritchett.
Did you obtain pre-application advice on the policies applying before you paid for the land?
Not pre-application advice, but I'm actually a town planner by profession, so I was aware of them, and I was also aware that we would have to go in and negotiate with the authority to make a reduction. And from what I'd seen of the equation, we felt confident in doing that. So no, we were aware of the policy.
Any final questions? No. So thank you, Adrian. And I'll open now for debate. So any members would like to open the debate? Councillor Higgins.
Thank you, Chair. So forgive me, I'm just going through the minutes of the previous meeting, and I think that's quite important because minutes don't really record a debate about affordable housing. Does talk about where the applicant was praised for allowing this carriage widening from 4 to 5 meters. And forgive me, I'm just quickly going through the original report because I'm sure I was at this meeting, but equally it's going on the affordable housing viability. The housing officer at the time says that the requirement would be 11 affordable homes, and that would have been policy by then, wouldn't it? Because we would have already done all that in the local plan. So that should have been well established before this land was purchased or the initial application came in. But it says here that there is no affordable housing in Howes and the low amounts in the parish. Melton Borough Council, since I was a councillor, was very positive about affordable housing, and it's still that today, as I believe. That all said, and I'm going to make this point because I'm not one to come straight in with a motion, but because as there's new councillors here, I'm going to leave it for a bit. But I think there's more information that's needed for me to make some decision one way or the other, because this is very complex and more information is coming out. I'm not comfortable giving a permit. That's where I will sit. However, so I'm probably minded to put at some stage a motion of deferment. And the reason I say that is if you look at various other legal documents, and it's not mentioned in here, and I might have this wrong because it may have been superseded by other court decisions, but there's a Parkhurst High Court judgment which landmark case dismissed the approach used by the appellant to determine the BLV. And then later on in this document, as I say, you can go all the way through it and we'll be here till tomorrow. So I'm not going to do that. But the planning policy guidance, yes. And I've said this before, under no circumstance will the price paid for land be relevant justification to failing to accord with relevant policies in the plan. Well, we've already had this plan and affordable housing would have been known. And I know, I think like Councillor Pritchett was saying, some of these other things would have been known. If this was never viable, it should never have got this far. And it's not, it shouldn't really be for us to throw away primary healthcare funding and then throw away a load of affordable housing. Probably this site should never have come forward and another site should have done, but we are where we are. So I've got lots more questions, but we're not going to answer them tonight. So I'm minded to go for a deferment.
Can you actually highlight some of the information that you feel we would need?
Yeah. So mainly it's like, it's some of the dates of when this was, and all these conversations, when were they had? And why does the applicant feel that he was saying, I always said that there was going to be no affordable housing, because really that would have meant a refusal right at the start, I would have thought, of this journey. And where we are now, it feels in the report, it feels that I have to make a decision with colleagues here to throw away affordable housing. And as Councillor Siggy Atherton was saying, there's going to be a lot of people then who can't get on the housing. And just because the economy has changed and values have changed, my house price goes down. I don't go back and say, well, it was worth this 2 years ago. It is worth what it is today. But equally, wages are being lost value, all the other stuff. If we start throwing away all affordable housing, we're going to not be housing anybody in this borough. And that's a big concern for me.
Okay, thank you. Anybody else? Councillor Evans?
Thank you, Chair. This is obviously an important, to me, it was a very important decision this council makes on the planning committee, because this is the first, as I understand it from the officer's viability report of a significant kind that we're coming to here. And there are very keen recognition on where you go from here. I'll give you a paragraph from an RCIS report about viability studies, which says, a review to intending to reduce developer contribution based on reduced income or increased costs would be an attempt to protect the developer return and is precluded under PPG paragraph 0092314. So it makes it very clear, and this report goes on, but in the event of a recession or other significant economic change, such as an immediate aftermath of a major economic shock like that caused by COVID, the ALPA may wish to review the plan to ensure plan delivery. All of these are key pointers, and the High Court has backed this up also in a recent evaluation, that the developer must demonstrate the maximum reasonable amount of affordable homes has been met when that amount is below the borough-wide affordable housing target. So this has been tested in High Court. It's been tested that we need to do something. I honestly believe the developer has been an honest broker throughout this, but we cannot, because I cannot, and I'm looking at the officers, think of any real material reasons why this. There are two other sites in Howes, very similar. And if this one goes through, and I have to be honest, the other two will have the same. They're just the same kind of plot. They've got outline planning permission. They've been granted, as this one has, with affordable homes percentage as per the local plan and the neighbourhood plan. It's not just a local plan we're breaking here, it's the neighbourhood plan of Long Clawson. To me, that is wrong. We either need to defer this or to find a solution which actually, because this will, I have to say, to me, it could spread throughout the borough.
Thank you.
Because we're in an economic downturn, and I agree with, I know that the costs are much higher. Thank you, Chair.
Thank you.
Thank you, Chair. So just to kind of put this into a bit of context and to bring it back in line with the report, this application before members is the removal of a planning condition. So this is different to a Section 106 agreement. This was purposely put on as a condition. Paragraph 8.3.1 of your report gives you an outline of the original outline, where there was the initial concern with regards to viability. The applicant has also made it clear that at that time, he submitted some information with regards to the percentage of affordable housing which was possible for delivery at the outline. During the outline phase, the full costs weren't known. So at that point, there was no Section 106 agreement that could be agreed on all parties because costs at that time were unknown. Hence the reason that the Reserve Matters application was submitted and more definitive costs were obviously available then, and a full assessment with regards to viability was able to be undertaken at that time. Those figures have now come back, been scrutinised by external viability persons, etc., and they've come back as a non-viable site. Now, I think it's important to go back to Andrew's original introduction. You know, it is disappointing that this is come forward, and we are hearing what members are saying, but we have to take you back to the fundamental principles of the NPPF, the local plan, and indeed the neighbourhood plan as well, all of which state viability has to be proven, and if it is not a viable scheme, subject to independent assessment, then we cannot seek to retain that affordable housing element as it's been assessed and it's not viable. And that is a mechanism within the National Planning Policy Framework, the local plan and the neighbourhood plan. So I'm just hoping that gives members a bit more clarity on where we stand.
Councillor Higgins.
Yeah, thank you for that, Louise. But as I say, I've got there's huge amount. I was going to spend hours on this morning. I'm running out of time, but there's huge amounts of legal advice on this, and this is why I'm concerned. I don't have enough information of where I hear what you're saying, but as I say, when you look at, I mean, I'm looking at Lichfield's document, and like they're just saying here, for strategic land promoters and developers who have secured the option agreements with the pre-agreed purchase price implications, the updated guidance is potentially a significant problem, and one that could severely undermine site viability and deliverability. Going forwards, the issue of the BLV, and more specifically the application to uplift the EUV, is likely to be a key argument during the local planning examinations and inspectors to be called upon to adjudicate. But the one thing that cannot be up for debate is the price paid cannot be factored into any viability assessment or used as a basis to seek flexibility in respect for the application of policy requirements. And that's why I'm not comfortable yet, because I haven't had enough information, and I think this just feels a bit of a mess. Sorry, and that's where I am. So I'm not going to be voting with the recommendation, but depending on how the debate goes, I'm happy to put forward a motion to defer.
So we have a motion to defer.
I'm going to let other members speak,
Okay.
because it's some members' first time on the committee. So,
Louise?
Just the clarification with regards to the document for, was it Lichfield that you mentioned?
there's loads of legal documents I've read.
So
but
can I
that's-
take you back to the NPPF, the local plan, the Melton local plan and the neighbourhood plan as well, and the Melton SPD as well for our policies and documents?
Yeah, I know, but the problem is as it all says, there's another saying or sentence in those documents which always counters that. So yes, this is an argument to remove. I accept there's an argument to remove. There is an argument that it's not policy compliant. And is that in the benefit of the community? Bearing in mind, we're also not going to be funding primary healthcare, and they've got an objection here as well. If we allow this to carry on, various primary healthcare and this town at the moment, probably other areas, are really screaming out for primary healthcare provision. And that's a huge concern. If we're not funding those strategic partners, and we're not funding affordable homes for the next generation of, essential workers to come in, our economy, local economy will start to collapse.
Thank you. Any other members? Councillor
When I read the document last night, I was convinced I knew how I would vote today, having studied it properly. When I'm now being confronted with rehearsed, repeated statements from a document I haven't seen. This is Lichfield from a previous application, is it? Because I don't know what this is. What are we discussing now?
I'm apologise, but for committee members, it's just various case laws that have gone before either High Court. So I think Councillor Evans mentioned some cases. It's some legal opinion on what cases have gone before High Court or how viability assessments are viewed as. So it's just a counter argument to what's being presented to the committee.
Case law is not a material fact in deciding a planning application. Case law can only come into relevance if it goes to court. It's not for lay people to make an assessment on a judgment in a forum such as this. I'll let the officer.
Tom.
Thank you. I don't know what is being referred to. I know it's being called case law. So case law is legally binding through the English legal system, and we are bound to make decisions in accordance with that. I'm not aware that what's being referenced, though, is case law as so much. They sound like SPDs maybe for literally. I don't know. I haven't seen the documents, so I can't comment on those. I'll let Councillor Higgins come back in, so it might.
What the case they refer to is Parkhurst Road High Court judgment, April 2018. I don't, as I say, I'm not a solicitor, so I couldn't go into all the details of that. What I'm saying, the reason I can't vote for it is I think there's some more legal advice that we need, because I'm not comfortable at what I'm being told, and to follow the recommendation.
So going back to the original question, what is the details that you would require for?
So the detail I require, because as Louise said, the recommendation is there, and there is a case, and I acknowledge there's a case to remove affordable housing, but there are other cases, other councils, including cases that have come before the High Court, where the judgment has been where the developer hasn't been able to remove the affordable housing and get permission. So I think these reports are leaning one way and not giving me the information at how I could go against the recommendation, for example.
Back to Tom. I mean, how is that? How can we actually relate that to the decision we're making tonight? How can those cases be used?
Without actually seeing them and seeing what they say, it's very difficult to answer. What seems to be coming back, though, is this position of the BLV, the value originally. I don't know that this is a legal issue, it's so much a technical and financial issue. Are they not covered within the Thomas Lister reports that looked at the BLVs and looked at what the applicant stated? That is what it sounds like to me is being queried at this point, rather than a legal point. So I accept that there might be some case law that talks about when BLVs have been hyperinflated and things like that, but I think that's what Thomas Lister were asked to look at as part of the whole package. And I think, I'm just having a quick look through the reports back now, I think there was a section in there about whether the BLV was accepted.
Councillor Higgins.
I'm going to go around and say what this entire document is, but again, it is what various legal opinion is. I mean, it's like we're giving some other sites to review, but I think the Parkhurst one was saying, well, you can't assess that site and that site necessarily. So what's being put in front of us? That's why I'm really struggling with being able to go with the recommendation here. I've got too many questions on it.
Again, it's before we can sort of look at a deferment, we actually have to understand what is the information we would need to you do and come back with that.
I've got a deferment ready, motion ready, but I'm very happy for other, because as soon as I do that, just so other councillors are aware, they'll only get one say, and I'd like to hear more of their debates because.
Tom first. Yeah.
It's probably appropriate for me at this point to repeat the general advice we give about deferments. Deferments can be made on any item for further information to be sought or anything like that. What members need to be aware of, though, is non-determination. So planning applications have to be determined within a period of time. That is quite a short period of time. And normally what happens is the officers will get an extension of time until a certain date. I don't know what the determination date of this application is, and the officers will be able to advise. However, if an application is not determined within that point, the applicant has the opportunity to appeal that decision for non-determination. In other words, they take it to the planning inspector and ask them to make that decision. And of course, if that does happen, the council lose some of the ability to put on any conditions, anything that they want on that. So it's something members just need to be aware of. It's not so that you can't defer an item, but something that you need to be cautious of when doing so. Just as one final point, sorry, Chair, on the BLV stuff that was coming out, if I can just take members to page 43 of the pack. That is the Thomas Lister report that is appended to the report. I don't know quite what's being asked. I'm not an expert in viability whatsoever in the values. However, that may provide members with some understanding and some reasonings within the value from my reading. However, I apologise if that's not actually what's being got at, but that may provide members with some assistance.
Which one was first? Councillor Evans?
Thank you, Chair. I've been, as a ward member, I've been on this since the start. And I can assure you throughout, and unfortunately the parish council has no longer the same chair, but the parish council and both myself and the other ward member never had any doubt early on in the outline stage that affordable homes would be delivered. It was never in the meetings discussed that there would be non-affordable homes. I can assure you of that. I'm absolutely certain. And when it came to full planning permission, the need for 11 affordable homes was discussed, and at no stage did anybody at that meeting and at the committee meeting say they would not be delivered. We always have doubts because developers always have doubts about these situations. Like Councillor Lee Higgins, I have real concerns about here. There's all kinds of, this is a very complex area. I've read quite a bit of it. You have things like existing use value, alternative use value, benchmark land value. There's masses and masses of documentation about this. But RCIS report is definitive in saying that a review intending to reduce developer contributions is precluded under PPG paragraph 0092314. It's definitive, and it says that cannot happen at a late stage. I therefore find it very difficult when they are a very, very competent body, when they say that, why are we even thinking that?
Before I come to you, Councillor Pritchett, can I just come back to Tom for a second?
Thank you, Chair. Councillor Evans, there's some mention there about what happened when this application first came in. I'd just advise members to be cautious in what we're looking at. The applicant alluded to the fact that it's quite common that applicants will sign up to things at that outline stage. As we know, when the outline applications particularly come in, they really are a proposal. There's not that much sort of that's gone into those at that stage. These things tend to get drawn out later. Viability is a genuine mechanism, and it is something that we can look at now. So it's just to be cautious in what we're looking at historically and focusing on what we're looking at now.
Sorry, Councillor Pritchett.
Thank you, Chair. I can fully relate to Councillor Higgins. We're very much concerned about the provision of affordable homes. And I know Councillor Higgins has been a champion for affordable homes, and you look at this and you think you feel uneasy about it. Half of me is with Councillor Higgins. The other half of me looks at this and says, well, the land price value, which it's been vetted as within parameters, the costs have been vetted, and the sales prices have been vetted, and we've got the outcome. And there's going to be a review later on in case things shift in a year as the things get built and sold. So it could be looked at quite simply, relatively simply, as well as looking at it a little complicated.
Thank you. Councillor Siggy Atherton.
My concern is that the applicant said right from the word go, he wasn't going to put affordable housing in. So how could he get to here now and be still discussing it when he said from the very beginning, if I quote him correctly, he said he wasn't going to put social housing in. Surely this should have been dealt with at a far earlier stage than this late stage, or am I wrong here?
Louise.
Thank you. So as I referred to earlier, the 2019 application, at that point, the applicant said there was viability issues, but the full costs were unknown. So until the Reserve Matters application came in, we didn't have an idea of the full costs. Now we're in a position that all of the costs are known. They have been challenged through the viability assessment, who is RICS assessed as well, by the way. And that has come back as an unviable scheme. So it's only at this point that we actually know the true final amounts of the costs.
Thank you. I understand that, but he says he's had numerous conversation, if I quote him correctly. I'm looking at him, he's not looking.
I'm afraid you can't answer. Yeah.
That he's had this conversation with you. So if he was always adamant about it, why did we still go one road when he was going on a completely different road all along?
So again, it's only until the full amount of the costs are known that we can actually go through the viability. So that's what's now happened, that we've got all of the information and it's been assessed.
Any other points? Councillor Gordon.
Yeah, as soon as he realised right from the start, actually, that he wasn't going to have affordable housing, he should have made a different way of building his houses, so it would be more simpler, so that it could have at least a few affordable housing, not necessarily the whole amount. And because that's one thing that worries me, because obviously when you start to build, you are supposed to know that you can get to the end. Do you know what I mean? And I just think, and he has got a planning background, so really he should have known. And I do think he should have made simpler houses. Yeah.
Thank you.
Okay.
Any other points? There's no more questions, so therefore, sorry, Councillor.
Sorry.
Sorry, thinking the debate had finished. Apologies first for arriving late. That was the taxi driver, and he blamed the lack of the bypass. And you hadn't started the debate, so will I be able to vote? I presume I can.
Thank you, Councillor. It's a decision for you to make. So the point that you arrived, the officer was going through the reports. I'll ask the officer to confirm whether there's any additional information within the report at that stage that wasn't contained within the reports or circulated to members. But provided that you consider that you have heard enough of the application, you've listened to the speakers, the debate, it's a decision for you to make. But I can just ask Andrew if there was anything else particularly that was raised. I don't believe there was, but I'll ask Andrew to confirm.
No, there wasn't.
Thank you. In that case, if there is no more statements, can I ask, are there any proposals? Councillor Higgins.
Yeah, I mean, as members before on this committee will know, I'm absolutely always, I abhor deferments, and it's only because of the absolute complex nature of this. And I think we've got to look at, one, I would like to defer this, not for an ordinable amount of time, because, you know, the applicant does deserve it to be determined. But I'd like either more confidence in the reasoning of why we should be permitting this, because equally going back to, and I'll say this, the Park Road judgment and the subsequent modifications of 2019 NPPF and PPG, I'd like to know how that would impact on us as decision makers. How much value do I attach to this, these assessments, which I acknowledge, but equally, I'm also surely, from what I'm reading from the National Planning Policy Guidance and other policies and court judgments, that I'm also allowed to weigh that balance against the other concerns that we have. And I think the concerns are obviously the provision for primary healthcare, because that's going, and also the removal of a strategic objective of this council and the local plan of affordable housing. Now, going back to what the applicant said, if they're all discount market houses, but the other question is, have Homes England been involved in any of these discussions? Because when I got a site with 8 houses on, Homes England gave a huge grant to get 6 houses on. I haven't seen anything of that in the report. So that's the reasons for my deferment, Mr. Chair. Thank you.
So from my understanding, if we do go for a deferral, we need to know what the course of action is to actually then come back so that we can make a decision. Do we feel we need to know what that specific questions we need to ask? Louise?
Yeah, thank you. So the reason for deferral is to look at the Park Road judgment. And then, and others, which others?
I mean, where I mean, you can Google some of them, but it's, for example, where applications are refused because affordable housing are taken out, and a judge or an inspector
So
has
decisions
appealed,
related to removal of affordable housing.
Yeah. So how does a higher body come to this very difficult judgment? Because I think that there's definitely some out there, and I think I would benefit to know that. So I can balance up the viability study, which I do accept and is weighing in favour of the recommendation, but there are other strategic priorities for this council: affordable housing, delivering primary health care. And I've got to assess that up, because going back to when before the local plan, harms and benefits. And if we're having all housing everywhere with no infrastructure, it's going to cause issues for the local economy.
Okay, so in terms of the actual reason for deferral, you want us to look at some of the appeal decisions, which I understand and I can certainly look at. There's concern with regards to the primary healthcare. Within the report, it's the matrix within the developer contribution SPD. So there's nothing that we can actually give you further information or we can do in relation to that. So again, I just want a bit of clarification as to what you expect of officers to be able to bring it back to you.
No, I think that's a factor weighing in refusing the application, refusing the removal, because if the site's not viable, it's not viable. And the key elements of the 2019 NPPF and planning policy guidance, with the introduction of requirement to apply EUV plus approach.
So that would be covered within the viability assessment that was undertaken, as I understand.
It mentions EV plus once in the entire document.
So what we would do in terms of viability, we've had it assessed independently and we've got the results back. There's nothing further that we can do in terms of that and allowing it to bring it back. So I'm really trying to narrow it down as to what further information we can give you to enable you to make a decision. And at the minute, I've got the further appeal decisions and judgments.
Just going back to where it says, I think this may have been mentioned before, the amendment being reinforced in the planning policy guidance on 5 separate occasions states, and this is quoting the planning policy, under no circumstances will the price paid for land be relevant justification for failing to accord with the relevant policies in the plan. And we're going to be failing to accord to those planning policies. So I just need to make sure that that's also taken into consideration as well. Thank you.
Councillor Pritchett.
Picking up one of the points Councillor Higgins has said, there's what is missing from this report is the creative aspect of, okay, we're in a pickle here with affordable homes. Have we turned every stone over? The Homes England, housing associations, even partnership with the council buying some. It doesn't tell us if we've tried to do our best outside of this particular issue of which council, and I would say that's a valid point to put on the deferment. It's what's not here on that would seem to me legitimate from what Councillor Higgins has raised.
Louise?
Thank you. And again, Councillor Pritchett, understand the comments that you're making as well. We have to be specific here with planning. We appreciate there are lots of other elements that contribute to this scheme as a whole, to the provision of this housing as a whole. But we have to be very clear that the decision that you make as members and the recommendation we give you as officers, professional recommendation, is contained within the limitations of planning and nothing outside of planning.
Councillor Mason?
Whilst I may not disagree with Councillor Higgins, can I be up before we have a deferment? Can I be absolutely certain on the risks of deferment? I know that Tom's already given us a view on it, but do we understand the timescales associated with deferment now? So, at deferment, if it was deferred, what would be the risk associated with that? Because that would give us a balance of where we are. That might aid or detract from the deferment.
Done.
Yeah, so I can't give you an answer of how long it will take to get the application back to committee, and ultimately that's where the risk lies. I think the extension of time from for this application is it next week?
9th of June.
Oh, the 9th of June. After that time, if the application hasn't been determined, the applicant could appeal it for non-determination. Whether they will or not, I don't know. The risk, like I say, though, is that the planning inspector will then determine the application. So it's weighing up the risk, really, in that deferral of whether that's something that members are inclined to do. But that's the risk, that it's taken out of your hands effectively to the planning inspector.
Councillor Mason again?
Within the planning framework, is there some sort of preeminence of viability over affordability, affordable homes? Is there a pecking order that arrives at the planning decision that a viability, if you like, trumps
Louise,
affordability?
do you want to answer?
Yeah. So I think what you're asking me is, how relevant will the viability be to an inspector's decision? Is that correct?
Far more eloquent, thank you.
Okay, so the information that we've provided you within the report, again, from a purely planning point of view, is the outline of the policy, the supplementary planning document and neighbourhood plan, all from the National Planning Policy Framework. We've combined all of that into a planning committee report. A planning inspector would look at that as an evidence base and assess the compliance with the planning policy, but also the mechanism to remove the affordable housing through viability as a legitimate mechanism within policy. And then an inspector would give a review of that. And I think it was Andrew or Tom pointed out earlier, both of the figures from the applicant and the independent assessor are pretty much side by side. So it's likely that a planning inspector would look at viability as a legitimate mechanism, see the figures, and it's likely that they would permit the application.
Councillor Higgins and then Councillor Gancy. Sorry, Councillor Cumbers.
Yeah.
And then Councillor Elmer.
Yeah, just to say, I think,
Councillor Higgins first.
oh, beg
Yeah, it was just a quick clarification on to the solicitor. Because while you're saying that is if we determine it, so let's just for argument's sake, so appeal goes in for non-determination, but if we determine it 3 or 4 weeks after that, then it's been determined. Because I'm not asking for something which I think is going to take months, and I hope it isn't going to take months, because I'd like it back ASAP. But
My understanding is once an appeal is put in for non-determination, it's taken out of the LPA's hands. The officers, it's not something I've come across yet, but that is how I understand it works. So once the non-determination goes to PINS or the application for that, it's taken, the LPA can't then determine it.
Councillor Cumbers.
Thank you, Chair. Yeah, I think as a committee, we're trying very, very hard to do the best we can. And we need to rely on the information we've been given. And if we think that we could have some more information to help us make a better judgment, I think we should receive it. And in the end, I think officers are there to advise us. The decision in the end, I understand legally is ours. Now, if we were going to propose something illegal, then I think that's fair enough for the solicitor to warn us and tell us we shouldn't be doing it. But I don't think that's the case, is it? I think we're perfectly okay to ask for deferment to obtain more information.
Just come back to Tom before I come to Councillor Allnut.
Yeah, that's perfectly correct. So my job and the officer's job is to give you professional advice and to warn you of the risks of any decision you make, whether that's to defer, to permit, or to refuse an application. In this instance, because we're talking about deferment, my position is to just warn you of those risks. It's not something that you can or can't do something. It's certainly not illegal to do. It's purely to highlight the risks of any decision that you are looking to make. That's my job.
Councillor Allnut.
Yeah, I understand that we can make decisions that override officers. That's always the case. And unless we're doing something specifically illegal, we can't be stopped. However, at a later date, if a higher court decides that we acted irrationally, albeit for good motives, we can get a severe rap on the knuckles. Now, I read this document back to front last night, and it seemed to me at the time that we were between a rock and a hard place, because we all want the things that we've been describing. Unfortunately, this council has not done its homework previously. Had it done its homework properly, and I can say this with some glee because I wasn't here, we wouldn't be in this pickle now, right? But we are in a pickle, and may I say, deferring it on the basis of asking for a legal opinion about a case or a series of cases will lead only one direction, and that is our officers will say they cannot give us advice on that. They will have to seek advice outside of this council, because once you start trying to assess case law, it's beyond their pay grade. Basically, they can give it an indication, but that's where it will go, and that will lead to a lengthy deferment, and it may happen again. Now, I think, candidly, I don't like this proposal because it's asking us to make this ridiculous choice. Now, I asked a question at the outset about basically, in Jim's words, whether the review of viability trumps planning guidance and regulation. Now, if you read this report properly, that's what it's saying it does. That's what it's saying it does. So I cannot vote for deferment, and I will be voting with the recommendation reluctantly, because we've got ourselves into this, and I would hope that in the future we don't get into the situation by having a bit more presence of mind and forethought when considering future applications. Thank you, Chair.
Just come back to Tom.
Yeah, so just to confirm, the council has a legal team. That's the part that I sit in. We can look at case law where things get quite complicated and we need a particular expertise. Then yes, we do go externally. It's very hard to say what's the case law on this without actually knowing what that legal point is. So there are hundreds and hundreds of cases, and we don't have an ability to just say what is that case law. We would need to have a legal point to look at, whether that comes from a statute or anything like that. What the question seems to be, and the way I'm understanding this, is what the PPG or the NPPF says about viability as a whole. And I think what you're asking members is viability a legitimate scheme? And does that trump, for want of a better word, our local plan policies? Because, you know, I think we all acknowledge that we don't want to lose affordable housing. That is against our local plan policies. But is there something that exists that says viability is a thing? And actually, yes, it does. I can't answer that. I'm not a planning officer, but I'm hoping that one of the planning team can answer that. And I'm asking them really to explain what viability is, where does it come from? Is it a genuine thing? And hopefully that might give some assurances to members and be able to at least guide us in that decision.
Andrew?
Thank you. Yeah, so it is within the National Planning Policy Framework, and the planning practice guidance does allow for viability as a tool. It's a mechanism within the determination of a planning application. So although the local plan policy says that it needs to provide a certain number of affordable housing, and the neighbourhood plan does as well, we have to consider viability, and even those two policies within the neighbourhood plan and the local plan does take account for viability considerations as well. The NPPF places the requirement on the applicant to demonstrate the viability, and that's where we've then gone out to independently and externally review the assessment that's been submitted. We've done our robust analysis, not only just on sort of the viability assessment that's been submitted, but also I think as I touched on earlier, about the costs and the detailed costs behind what the application is being submitted. Just touching up on a couple of points about benchmark land values as well, which was mentioned earlier. So that was agreed through this process as well by the independent assessor. So there's no cause for concern, shall I say, in terms of the developer or the applicant paying higher than they should have done. And that was formed part of that overall assessment. So yes, viability is a consideration that we have to consider. And it's in this instance, because the outcomes of that viability report show a negative viability, not only when it's 32%, but even any percentage of affordable housing, then we need to, consider that seriously. Thank you.
Councillor Ian Arnott.
So I've kind of sat on my hands during all of this, Chair, and like yourself, I'm brand new to all of this, and it's a shame that this has come up first because it's quite complex. And I have no prior knowledge or experience on which to gauge the information presented in front of me, other than the training that we've been given over the last couple of weeks. And it seems to me that, as Pip said, we are caught between a rock and a hard place. Yes, we all want more affordable housing, but no, we don't want to do it for the sake of doing it, if that makes sense. I haven't yet had a chance to read the various town plans or whatever. I have no legal background. It worries me that we've got to make a decision within the next 3 days, or run the risk of it being taken out of our hands, sent down to Whitehall, where the decision almost certainly will be, yes, do what this document is suggesting. The only facts that I've got to base my decision on are these in this document. That is a concern to me at my stage of my career as a councillor. But I am reminded, because I wrote it down, of one of the statements made during the training. If in doubt, we have to put the balance onto the positive and go with the recommendation as made by the officers and the legal advice. And that's it. Thank you, Chair.
Thank you. Tom, can you just quickly respond, and then I'll come to you, Councillor Mason.
Yep. Sorry, I just want to make clear, it's not a threat of any sort to say that if you don't make a decision by that date, that's what's going to happen. Officers also have to abide by those rules. They have the same times. It's not to say that the applicant will appeal the non-determination. It's purely a risk, and as my job, as I said, it's to highlight the risk to you. I don't know how likely that is. It may not be at all, but I have to let you know that that is a risk and a possibility. But I still want it to be considered that you must make a decision today to permit or refuse. You are able to defer, but I have to highlight the risk to you. That's all I just wanted to make clear.
Councillor Mason.
I'm as one with Councillor Higgins on affordable housing. It is the cornerstone of the planning policy, no doubt about it. To my mind, it's a balance of risk. Tom, you alluded to a balance of risk where we could lose it all if it was appealed. Is that correct? Is that?
It's not that you could lose it all necessarily. The point is, if you are making that decision tonight, to say permit the application, you could look at things like the late stage review. If that decision was taken out of your hands and the planning inspector did it, it would be them looking at whether that was necessary, whether they considered it relevant to do, and that would be a decision that they make. And whilst the council would obviously put an appeal statement forward and put those things in, the council aren't the decision maker anymore, it's the planning inspectorate. So that's the risk of what you could lose. It's the authority or the ability to make those decisions. So that's what I was alluding to.
Councillor Pritchett.
The major question about a deferment is, can it magic up money? It can't, can it? I don't think.
Thank you. Any other? Councillor Evans.
Thank you, Chair. I'm still going back to this report, and it has a definitive sentence in it. And all the way through this paragraph, it talks about in event of a recession. It's been written specifically for the situation we're in, which is where developers who take a risk when they buy a piece of land, they know that they take a risk. My dad was a builder. I know about these kind of things. They take a risk, and it's their risk, not our risk. It's their risk to invest in it. And it quite clearly says a review, which this is, to intending to reduce developer contributions, which this is, based on a reduced income or increased cost, which this is, would be an attempt to protect the developer return and is precluded under PPG. This is the Government Act, paragraph 009.2.314. That is a definitive statement that we cannot, at a late stage review, this is a late stage review on this development, there are already bricks and mortar down there. We cannot, and I believe, and I know Tom may look at me differently, that to me is a definitive statement that protects us from anything the inspector brings, because that to me is a statement of fact. And until the officers say, no, that isn't the case, I think we need to defer, and I'd agree entirely with Councillor Higgins here.
And just come to Councillor Siggy Atherton, and then we need to start looking at proposals.
Sorry. Just to confirm, I think Councillor Higgins did actually put a motion forward to defer. Councillor Evans, when you just made your comments, was that you seconding that motion? Can you put your microphone on?
Chairman, that's the second of Councillor Higgins' motion.
Councillor Siggy Atherton.
At the moment, I feel like we really are stuck. That, yes, we would love affordable housing in house. There aren't any at the moment. But I wouldn't like to lose our little bit of leeway that we have, that we can look at things later on if we say yes, and maybe have another conversation with the builder and see what can we do? How can we get some money into healthcare and things like that? If that all is taken out of our hands, I think that's going to be a bigger concern to me.
So we have a motion to defer.
Can we just confirm that?
Sorry. Louise? Sorry.
So the motion to defer has obviously been put forward by Councillor Higgins and seconded by Councillor Evans. I'm still not entirely clear on what it is that you want from officers and what we can bring back to you at the next meeting to enable you to undertake the decision. All I've got so far is a review of appeal decisions with specific reference to the Park Road judgment and how that can balance against the recommendation put before you.
Would also be the motion, the part that Councillor Evans put forward as well.
I also, sorry, Chair, I thought, Louise, it was quite clear there's a sentence that makes it clear. PPG paragraph 0092314 makes it very clear that a late review, which would reduce the contributions by a developer, is not permitted. Those are the words that are used. And this is by RCIS, who know what they're talking about. So please, could we look at that, find what the PPG is, and find out why a very significant body in home building have said that. And by the way, just to add to this, there isn't a developer appraisal tool developed by Homes England for borough councillors to actually look and assess independently with their own officers of whether this is factually correct or not. So we don't need to go outside to make certain that this is correct. They've developed an online tool to do all of this. Thank you.
Okay.
Chair.
Louise? Yeah. Do we think we've got enough for a deferral vote?
I've got clarification, so it's up to members to vote.
And just as the proposer, I'm happy to put that in, but could Councillor Evans just reveal the PPG again? So I was busily typing it away. Thank you.
So I've got it as
PPG paragraph,
PPG
and I've got
zero.
a printout if you need it. Paragraph PGP paragraph 009.2.3.14. I'm almost sounding like a solicitor or something. Thank you.
Happy with that amendment? Yeah.
Sorry, just for members' benefit, obviously PPGs and PPSs are always being updated and changed. I just want to make sure the officers can actually find that particular paragraph before we move on, and just in case it has changed, so we can make sure we are talking about the same thing.
Just to say, Tom, this is obviously because it mentions COVID-19 pandemic and all the rest of it, so it's obviously not an old document.
No, so when we just had a look at it now, obviously PPG is guidance. It's not actually part of policy framework. It's the guidance behind it. So that changes more regularly than the actual legislation and the policy. So what you're looking at is a supporting text of and some guidance, not physical policy. We've gone and had a look at it just now, and the paragraph number doesn't exist. There's a revision of one in 2019, but the actual paragraph number that you've stated, we've not got.
Do you have a copy of it now, Councillor Evans, that we could?
We've got a printout, Councillor Don Pritchett's reading it now, so I can't believe that the RCIS would have got that wrong, but you can certainly have a copy.
Well, while Tom's looking at that, can I just come to Councillor Adams?
I understand the quandary we're in. I thought that was quite a helpful contribution from Councillor Evans. I do respect him for that. He referenced Homes England providing a tool. Now, if that's a route to also burrowing into the which particular PPG we want and whatever, that might be if that's what he's saying, that they provide a tool that would provide a further assessment of the rules rather than the actual values, that might be helpful. But I don't know what he's talking about.
Are you saying, could we use that tool, or could we look at using that tool? Is that part of the late assessment? And that would be another reason for deferral, to check that we can use that tool.
Sorry to interrupt. Homes England are very keen for the borough councils to get involved in using this, because viability issues are a very important point at the moment. I know I sympathise with the officers, because it's.
Councillor Evans, sorry, I've just had a very quick Google. I'm struggling to find everything. Can you just let us know where that's been obtained from? It might, but where did you obtain it from? Just it's going to assist officers to be able to. Okay, but you don't know where. Okay.
It's an RCIS report, so obviously I can't tell you the exact one, but you can see the context of it and everything. It's not I'm trying to put this carefully, it's not an individual who's just made it up. It's an official RCIS report.
Okay, thank you. Appreciate that. So it's not policy, it's not legislation, it's not framework. It's from a qualified body, understand and respect that. Can I just again reiterate that the information that's provided to you in the appendix of the report is the viability assessment, and that again is an RCIS qualified assessed person, so of the same qualification and professional membership as this information is referring to.
And the RCIS report says also, and you can probably read it out yourself, they have deep concerns over some of the viability reports coming from some of their members.
I don't think we can take that as a statement. I think we have a motion, so I think we'll have to say that motion to vote. So all in favour of the motion? Yeah, can you keep your hands up? 1, 2, 3. 5. Any against? 4. And yeah, yeah. Any abstentions? No. So the vote fails. We're looking for another proposal. Do we have anybody? Yeah.
I move the recommendation from the officers. To accept, yeah. The officers' recommendation.
Do we have a seconder for that?
I'll second.
Councillor Pritchett, thank you. So, yeah, can we take a vote on all in favour of taking the motion as proposed? All in favour? And those against? Yeah. Any abstentions? Yeah.
Sorry. Can I give my reason for abstention? The fact that I don't feel I have enough information. Thank you.
So that's 5 votes for, so the motion is carried. I'll just add to the end, though, that we need to make sure 2 things. One, we don't actually get back to this position again. So whenever we, in the future, we don't get through. But the second one is that the late review is actually carried out as, I'm trying to think of the right word to use, but as expeditiously as is possible, and to make sure that if there is any discrepancies in there, in any of those, that we actually recognise those.
Could I have my vote recorded for the same reasons Councillor Cumber said? I didn't have enough information to vote for the recommendation. Thank you.
I was going to say ditto. And I presume my
Yeah.
No, sorry. So Councillor Cummins, are you asking for a recorded vote as well?
I presume my name was recorded when I made the point that when I gave you the reason for my abstention. But I
Okay.
do want my name recorded. Thank you.
Okay, sorry, I hadn't appreciated, Councillor Cummins, that you wanted your vote recording. So members, 3 members have now asked for their vote to be recorded. In accordance with the Constitution, that requires a fully recorded vote.
No, I'm not asking that. I'm only asking for my own personal vote to be recorded.
Yeah, but the Constitution requires that where 3 members or more ask for a recorded vote, the full vote becomes recorded.
I was going to say, I didn't think we never used to do that.
Let me check the Constitution.
Yeah.
Councillor Evans, are you?
I'm asking for my vote to be recorded too, and I think you are right, Tom. It does mean that there has to be a recorded vote because you've got 3 people asking for.
Can we just pause while we've got a member out of the room?
Can we just take?
So we'll just wait for the member to come back into the room and then we'll take the vote again. And do, yeah, do you want to, we'll take a break as soon as we finish this. If you can, yeah, just wait 5 minutes. So we're just checking the constitution.
Okay, thank you, members. Is everybody back in the room member wise? So just check what the constitution says. So a recording of the vote will take place if 3 members present at the meeting demand it. There is also obviously a right for an individual member to request immediately after for their vote to be recorded. My understanding of 17.5b, which is the 3-member rule, and this is of the general meeting procedure rules of the Melton Constitution. For those 3 members to demand it, I think it's got to take place before the votes. Otherwise, we're effectively taking a second vote. What that means is it won't be a fully recorded vote on this occasion. However, any personal member that wants their vote recording can be done so. So to confirm, Councillor Cumbers voted an abstention and gave a little reason why. Councillor Glancy and Councillor Higgins both asked for their vote to be recorded against the motion. Are there any other members that wish for their vote to be recorded? So Councillor Evans, who voted against the motion, and sorry, Councillor Gordon, still learning. Can you just remind me how you voted against? So Democratic Services, are we happy? Yeah, there was 4 against and 1 abstention, 5 for. Okay.
Is Councillor Gordon who voted for the proposal?
No, I didn't. I voted against.
That makes 4. 2 on that side, 2 on this side, makes 4.
Councillor Gordon, how did you vote in the initial period? Was that against? Against, that's what. Yes, so Councillor Cumbers, you abstained. Councillor Glancy, Higgins, Evans and Gordon voted against. Councillors Pritchett, Siggy Atherton, Ian Atherton, Councillor Ornett, Councillor Mason, you all voted for the application. So by my maths, and Councillor wait, you didn't take part, you abstained as well. So by my maths, that is 5 that voted for the motion, 4 that voted against the motion, and 2, when we include the chair, that abstained. So that vote carries 5 for and 2 abstentions.
So that motion is carried. Apologies to the next applicant. We're just going to take a 5-minute break, as that one took a little bit longer than we expected. So if we just take a 5 minutes break and we'll come straight back to the next application. Thank you. As soon as Louise returns, if we can get started again. Okay, if we can restart the meeting, please. Were everybody present? Yeah. Therefore, if we can move on to the second application, it's application 21/01134/FUL, 2 Mill Lane, Long Clawson. And I believe it's Andrew again.
Yes, thank you very much, Chair. So again, just to start and just to let members know that we've received 3 further letters of objection, raising concerns around flooding, access, traffic, footpath to the village, and that not everyone was notified of the application. So all of these matters are assessed already within the committee extract itself. And I can confirm that everyone that was required to be notified was notified, and a site notice and a press notice was also posted. So this application is a little bit different to the norm. It's a hybrid application. So it's a mixture of a full planning application and an outline planning application. Next slide, please. Thank you very much. So the full planning permission part relates to the demolition of the existing property, a number of outbuildings across the site, and its replacement with plot 1, which is the dwelling in the sort of bottom left, most southwesterly corner of the site plan here, as well as the access arrangements and the replacement bridge onto Mill Lane. Plots 2 and 3, which are the other 2 dwellings further to the right, they are in outline form only, and only their layout can be considered. The site is within the limits to development of Long Clawson. It's also within the conservation area of Long Clawson as well. The principle of residential development on this site is considered to be acceptable, subject to the material planning considerations. Access would be via Mill Lane. The applicants are proposing to widen the access arrangements to improve visibility and to ensure that the access is of a sufficient width for the development that's being proposed. Flooding has also been carefully considered. The applicants have undertaken a site-specific flood risk assessment, as well as an additional drainage note, which demonstrates that the drainage strategy would actually improve the existing situation. And there's been no objections raised by the lead local flood authority or Severn Trent either. Next slide, please. So plot 1, which is the full planning application, and this is the one that's set right back into the site. So the elevations are shown on the screen here, showing a simple designed bungalow, which reflects sort of is quite a mix of character in the area, predominantly red brick, which this would be reflective of. It's also proposed that plots 2 and 3 are to be bungalows. And just responding to a member query that was raised last week regarding restricting the height of plots 2 and plots 3, that can be a condition in terms of sort of making sure that those plots 2 and plots 3 are single story when the reserve matters application comes in. Next slide, please. So there was a previously refused application on the site, and on the left-hand side of the screen, you can see the refused site plan. The reason for refusal for the previous application related solely to the introduction of the car park, which you can see on the sort of the right-hand side of the site. The car park has been removed from this proposal. Everything else is effectively the same, except for the car park being removed, and also there was another house on the other side of Mill Lane, which has also been removed from the proposal. The previous reason for refusal has therefore considered to be overcome as a result of the removal of the car park. And as such, the application is recommended for approval. But just to remind members, if you consider that it's fundamental to include that sort of limitation regarding plots 2 and plots 3 in terms of their height, then that's something that you can consider as well. Thank you.
Any questions for Andrew? Councillor Evans?
Is it possible to have that slide back on again, please? The planned slide. Sorry about that, Aaron. Could I ask what the distance is between the existing dwelling in the southwest corner and the plot 1 development, because it looks very, very small.
So you're referring to the building in the sort of the bottom left-hand corner?
The one that we're going for full planning permission, it obviously
Yeah.
has some kind of structure on its boundary or close to its boundary already existing.
That's right. So that's just recently been built, and it's a outbuilding for the adjacent house. So it's not actually a house itself. It's
Right.
sort of a gym games room that's been permitted. That is right on the border of this site. But because it's not a house, it's not considered to be any sort of residential amenity impacts as a result, one way or the other.
Is that a permitted development or is it?
That is, yes, as in it got planning permission.
Oh, it got planning
Yes.
permission, so it was rather than being a permitted development.
Yes, I think it was slightly bigger than what was allowed under permitted development. So
Right. Okay.
Any other questions for Andrew? In that case, then I'll call forward the agent, Rob Hughes, talking for the application. You press the face in the middle, the red light will come on, and you'll have 3 minutes, and Tom will warn you when we have 30 seconds left.
Okay, thank you very much. Good evening, all. I'm Robert Hughes, the planning agent acting on behalf of the applicants. I would like to start by endorsing the Assistant Director's recommendation for approval. The recommendation to approve is made having regard to the statutory development plan and all other material considerations. The application site comprises an existing bungalow, large workshop, and other ancillary outbuildings located within the defined limits to development and within the conservation area. The site is bounded on 3 sides by residential development with access from Mill Lane. The proposal comprises the demolition of the existing bungalow, workshop, and all ancillary buildings, and the erection of 3 new bungalows together with associated works. The bungalows are to be sited on the central and rear part of the site, and the existing access from Mill Lane will be used. In terms of the principle of the development, the redevelopment of this previously developed site located within a sustainable village wholly accords with the statutory development plan. The most important material consideration in this case comprises the previous application on the site, which was refused by Planning Committee in March 2021. Members will be aware that in cases where permission is refused, they are refused for very specific reasons. In addition to the 3 dwellings as proposed, that application included the formation of a 10-space car park at the front of the site. The reasons for refusal related solely and specifically to the car park, which members considered to be unattractive and inconveniently located. The reasons for refusal did not relate to the 3 dwellings as now proposed, either in principle or in relation to their siting, layout, design and scale, or their effect on views along Mill Lane, or drainage, or parking, or pedestrian access, or impact on neighbouring properties. In response to the previous refusal, the car park has been omitted. The earlier reason for refusal has therefore been directly addressed in this revised application. We are aware that 3 members of the public, in addition to the Parish Council, have again raised concerns with the proposal. These concerns were previously considered by the Planning Committee, but deemed not to warrant refusal. There are no statutory consultee objections, and all technical considerations have been addressed in the application submission. There are no objections from the Highway Authority, Environment Agency, Lead Local Flood Authority, or Severn Trent Water.
30 seconds remaining.
Members will be aware that decisions in relation to previous applications are material to future decisions as a matter of law. Councils will be at risk of award of costs against them if objections are raised to matters that have previously been deemed acceptable. Having omitted the car park from the proposal, we ask members to ratify the recommendation for approval and to grant planning permission subject to conditions. Thank you.
Thank you, Mr. Hughes. If you would like to stay there for a second, and are there any questions from the members? No further questions. Thank you very much.
That's a bit of a surprise after the last one. Thank you.
I think you may have been lucky on that one. So if there are no questions, I'll open it for debate. Anybody like to open the debate? Somebody must want to debate. Councillor Evans.
Obviously, as a ward member, I suppose I have to speak about this. This is obviously the parish council have made fairly strong statements regards this development, and obviously some of them can be included, some of them can't be included. The history of the site, well, this area is one of fraught, because I know that it's been mentioned, so I think I can mention it. There has been 3 floods of Longclawson Central Village in the last 6 years, two of which affected very badly the local public house, and one of which nearly actually decimated the surgery, which happens to be at the bottom of it. As a committee, I just need you to be aware that we all know that we have to listen to our statutory bodies, but we did at Great Dolby, and we nearly had what could only be described as egg on our face. There is a culvert that is completely, well, 50%
I believe
old.
that
I know,
this is not one of the issues that we can actually discuss within this
I'm just giving the
application,
background to why this is here.
but it's not one of the conditions that we are discussing in this
Yes,
in
but
this
it was brought
application.
up by an officer, so I feel I have a right to say why it is still of concern.
Was that minuted in the last review?
Yes.
Do we need to state it again?
Well, I would like it put on record that I have still major concerns, because both the county council and the statutory bodies have not rectified the situation of the flooding. So obviously it's a concern locally. I know that as a committee we cannot do that, but I need to have that recorded for future reference. And that's because obviously the parish council have also put it in their submission.
I think that's fine, but as relating to
And
this
then we
application.
come to the view, and there is a bit of clarification. It wasn't just the car park, the principle of development on the site and the fact it could impact on the neighbourhood plan view, which it does. But I have to agree it's to a minimal level, but it still has an impact on what is, I can't remember the number, but a significant view on the Longclawson neighbourhood plan. The bungalows effectively go into open countryside in a conservation area.
Okay, thank you. Councillor Olnett.
Well, Chairman, I won't repeat what I said earlier, but I will. That I wasn't here when all this was done before, so I'm not to blame for this nonsense. But once again, we're being given information about what happened to a previous application in this one, and the reasons for it being refused at that time. And we are told by the officers it was because of the car park. Now, Councillor Evans, who I do respect, and he's doing a good job for his ward, he must do that, I respect that. But now he's introducing another piece of information that actually at the time other things were mentioned. Can I ask through you, Chair, if the officers can confirm or not whether there were other features to the refusal before?
There's my understanding, and I'll pass to Louise in a second, that they were discussed, but they weren't put forward as the refusal.
this, Chair, if I may continue, we're between this rock and a hard place again, because quite clearly we can't reintroduce things that have been dismissed previously, unless somebody tells me otherwise. Shall I stop?
Okay, yeah, so I appreciate again, we've got new members this evening. So the application that was put forward previously looked at a number of matters, the impact, the design, the impact, the drainage, etc. At that point, members discussed, debated all of the issues and formed one reason for refusal. The single reason for refusal being the impact upon that view. And that's what now has been amended through this submission to remove the previous reason for refusal. So ultimately, you can assess the information again, which is what the report has given you. It's given you a balanced assessment of all matters, but from a point of recommendation, the previous reason for refusal has been overcome, and there's no additional information which officers feel would warrant refusal of this application.
Councillor Arnold and then Tom.
Sorry, do you want me to stop?
Sorry, Councillor Arnold, it might just, it's just say, just to add on to what Louise said, this is a new application. The reason I say that is you can consider everything again. I think the point being made was when this application came previously, lots of things were discussed, but the one reason for refusal, from what it sounds, was the view to do with the car park. This application has changed that. So based on what the old committee thought, it appears that the issues have been overcome, but that does not prevent this committee from reviewing the whole thing again. It is a brand new application in that respect.
Okay, yeah, in that case, I feel a bit more relaxed about it. In particular reference to flooding, because I've come across this in other planning committees time and time again, where recommendations about flooding are sort of brushed over a bit. And I wonder what the Environment Agency and the Rivers authorities actually do when they get applications. And I speak from bitter experience because my pub was actually flooded in a similar situation. So I would like some reassurance about this, because clearly, I mean, views and all the rest of it is a bit marginal, but flooding is a bit a major concern. And I think it should be in our villages where we're looking at these sort of things. So I'd like a bit more reassurance on that, or not, as the case may be.
Andrew, can I ask you?
Thank you very much. Yes, so the application was initially submitted with a site-specific flood risk assessment and a surface water drainage scheme. And then a number of representations were submitted objecting from members of the public and the parish council as well in respect of flooding. So the applicant went away for quite a long time, to be honest with you, and worked up additional drainage strategies and an additional technical note in response to those concerns that were raised by members of the public and the parish council. That was submitted to us for our consideration. It looked at additional sort of scenarios and blockage events, especially with respect to the culvert as well. Those reports were sent to the lead local flood authority, who do provide the expert consultation advice to ourselves, and they haven't raised any objection to the proposals that were submitted, and neither have Severn Trent Water or the Environment Agency as well. I think in my opening speech, I mentioned about it actually improving the existing situation, because at the moment, sort of the drainage on the site is not existent. It sort of just runs off, whereas this would actually control it, and the flow that it would go off the site would be at a more controlled pace, if that makes sense. Thank you.
Does that answer your question?
I hope so. When you say they haven't made any objections, have they commented? Have they replied?
Yes, they all replied to say no objections, and I specifically sent the applicant's report to them as well.
Councillor Hean?
Yeah, I said this at the last time this was up, and it was just probably for new committee members. Somerby one had a flooding concern, and the parish council commissioned. I can't remember now who the technical experts were, but they commissioned an expert, and they ended up coming in with a very strong reason for refusal, and the recommendation changed from permit to refusal on that last day. It went to an appeal and the applicant had overcome the objections. And I said to Mr. Worley at the time, who was sitting where Sarah Legg is now, as was then, is for us to refuse on flooding, we would need to rely on a technical expert. And I don't believe we have that. And we have to also prove that flooding will happen to refuse that, rather than have the concern that flooding would have. Where at Somerby we had a concern and we was told by the planning authority we needed to get technical evidence, and the parish council managed to get that. So it's just experience what's happened in another site, but I'll let officers comment on that if they want.
Any other questions? Councillor Evans.
Councillor Higgins has reminded me that there was Councillor Steadman, in fact, financed an independent review of it. And one of the statements in that independent review was there are the unknown factor of the block culvert, because I believe the county council tried to get a camera down there and it disappeared, never to be seen again. It basically said no one can know what rate the culvert can take, because no one knows how blocked the culvert is. And that was just the statement made by the independent review that Councillor Steadman funded maybe 2 years ago now. So that's where we left it. All I can tell the committee is the practical experience at the moment is it's flooding every other year. And when I say flooding, it's sewage too. Up to when I was there, and Councillor Holmes would agree, it was up to my ankles and beyond all over the Sands car park.
Nicole and Louise. Andrew, sorry.
Thank you. Yeah. So the report that you're referring to was submitted as part of the consideration of this application. So that was sent to the lead local flood authority. It was also sent to the applicants as well to respond to, and that's where that additional sort of drainage note came in, which was all sort of bundled up over to the lead local flood authority for them to consider sort of the concerns raised by members of the public, and then also the response to that as well. So just to let members know. Thanks.
Sorry, Louise. Yeah.
Yes, so I think if I'm hearing correctly from Councillor Allnott, your initial question was a consideration of flooding previously and a consideration of flooding now. It was considered previously, and then through this application, additional information has been submitted and consulted on, and through that an additional package has been prepared, which would then improve the current runoff rate, which would reduce the likelihood of flooding.
Any other comments? No, therefore, can I ask somebody to put forward a proposal? Councillor Gordon, you propose to accept? Yeah, do I have a seconder? Yes. Sorry, Councillor Allnott.
Give me a hand, can't you?
Yes. Councillor Allnott seconds. Therefore, I can take this to a vote. All in favour of the proposal, please show your hands. And against? Therefore, the proposal is carried. Thank you very much.
Thank you, Chairman. Once again, could my vote be recorded, please? Thank you.
Yes. Okay, yeah. Thank you. If you wish to leave now, then please do so. We therefore come to the third proposal, which is application 23/00034.dis, Crossroads Farm, Eastwell. And I believe it's Helen that has the opportunity this time.
Yes, thank you, Chair. So this application seeks to discharge 3 conditions attached to a scheme for a mixed-use development approved by Planning Committee back in July 2022. Firstly, in response to questions raised at planning briefing, yes, the applicant is the ward member. And that's the reason that the application is put forward before you for a committee decision. It's not usual for committee to have to consider this type of planning application for discharge of condition. And secondly, yes, the work has begun on site. I'd like to draw members' attention to the fact that formal comments from the local highway authority dated the 5th of June, so yesterday, were uploaded to the website. They just confirmed formally that the local highway authority had no objection to the information submitted. So they had informally implied it, but we didn't have the formal response to them until yesterday confirming that. So if we go through the conditions, the first condition that is sought to be discharged relates to materials. So this slide shows the mix of natural ironstone, new red brick, reclaimed red brick, timber cladding and clay pan tile. It is the materials that were shown on the elevation drawings considered at the planning committee meeting. They're considered to be high quality materials that would both suit the site context and would enhance the setting of the neighbouring listed buildings to the site. If we can move to the next slide, please. The second condition that's being considered is condition 5, which relates to the discharge of foul and surface water. So the plan before you, although it's probably quite tricky for you to see because of the scale of it, shows that foul water would be directed to package treatment plants within the site, and then surface water and treated water that would come from the packaged sewage plants would be directed to an open body of water shown in the bottom right-hand corner, of the plan. And this approach is compliant with the drainage hierarchy set out in the MPPG and the Environment Agency's guidance, which we would use for a development of this scale. And then if we move to the next condition, next slide, this relates to condition 10, which is the construction traffic management plan. So with this one, a plan's been submitted to show that vehicles will be entering and leaving the site from the 2 existing site accesses. That vehicles will be routed to main roads, avoiding smaller settlements. No routing is required to the A607, which is the point of clarification that the local highway authority was seeking, and that the wheel washing facilities would be provided on the site and made available prior to construction starting, and then would be removed once construction have been completed on the site. So the recommendation is to approve the details submitted. Thank you.
Thank you, Helen. Do we have any questions? Councillor Evans?
Just a technicality, really. I believe the works has already started, so how can we impose a situation where a wheel wash is started before the work? Surely we have to say from now on, not before the work starts, because it's already started.
To clarify, as far as I'm aware, the wheel washing facility was made available prior to the commencement of the development on the application site.
Sorry, Chair, how could you possibly know that if we've not inspected and actually seen that? We'd have to just take the applicant's word. I'm just being technical here. If we're going to put a condition on it, it must be a condition we can enforce. We cannot enforce unless we're Doctor Who.
Is this relevant to the decision we're taking?
Yes, well, it is, because we're going to put a notice saying, our enforcement officer would say, can you tell me there was a wheel wash facility before work start? The answer is we don't know.
Yeah, I think the point is that we can only look at things from now. So you're being asked to make a decision at this point based on the evidence. But yes, if there was enforcement action to take later down the line, that would be looked into. But we can't look at something retrospectively in terms of that sort of thing. But you members being asked to make a decision at this point, regardless of whether the works have or have not started.
Do you have any more questions? Sorry, Councillor Higgins.
I'm just going to propose, I'm not a question, but the only question I will ask is, as I always have done on these kind of things and other councillors have, is if any member of the public would have normally, and the officer explained this, any member of the public or even, you know, the officers, if it comes to this, this is a very simple application, and it's just because this is a councillor, this would normally come up, but this is a very simple application. So I'm very happy to propose the officer recommendations.
And Councillor Gancy, you're wanting to second?
I'm very willing to second the application. Thank you.
In that case, I would like to put the proposal forward for vote. All those in favour? I think that's unanimous. Thank you very much. Therefore, there's no urgent business to go forward. However, I will call the meeting to an end, but I would like all members to just stay behind for 5 minutes afterwards, if that's okay.